And so there are two issues we need to take up, and both parties told me, at least Mr. Stevens informed the court, it would be 10 minutes.
Ooh,
He's
I'm joking, Judge.
he was like, Judge, could we not come in at 11 because it's only going to take 10 minutes? So should I hold you to that?
If you will not hold me to the minute and the second, I'll be quick though, Judge.
Okay. No.
Relatively speaking, can I say?
Yes. All right. The first issue, I'm sorry, Ms. Abrams. All right. So the first we have is a motion to suppress, and it has to do with the defendant's statement. Is that correct?
Yes, ma'am.
All right. So yesterday, the state and the defense both presented the court with a DVD video of the defendant making a statement. Is that correct?
Yes, ma'am.
All right.
Yes, Your Honor.
So the court had a chance to review that. If both parties would like to call witnesses, you're more than welcome to call witnesses. I believe I know what the issue is as stated by the defense with regards to that statement. If there are no witnesses, I will make a ruling on that.
Judge, I have Officer Salazar here who
Okay.
reads out the warning. I don't know if you want to hear from him or you feel like we need witnesses.
No, if you all want to call him as a witness, you're more than welcome to call him as a witness for that. But from the court's perspective, from what I saw in the DVD, the rights were read to 4 individuals who were in the room. From what I saw and what I heard, and if I'm incorrect, let me know, the defendant in this case never responded in the affirmative or the negative that he understood his rights. Is that correct?
Yes, correct, Judge.
He just started answering questions. Am I right in that rendition?
I don't think he ever says anything, Judge. He just starts responding to questions.
Yes. All right. So I'm assuming the officer is not going to say anything differently than what I've seen on the video. Is that correct?
Yes, ma'am.
So if there's no objections from the defense or the state, for purposes of the record, if you all would like to offer the DVD into evidence for this hearing, and then I will make my ruling in regards to that.
Yes, ma'am. We would like to offer the record. I guess since it's our motion,
Yes.
we need to sponsor the exhibit. Can we have that marked as perhaps defendant's pretrial 1?
Yes.
And you have that, I believe, physically.
No, they
or
have
in the
it.
back?
Yes, sir.
Okay.
Do you want to?
We have a sticker, Judge.
Sure. Right. So without objections, defense exhibits, what label did you give it?
PT1.
PT1 is admitted. Court has reviewed PT1. And it was the muted version that was presented to the court. Both parties are aware that the court reviewed that exhibit. With regards to the exhibit, is there any brief argument that either side has? I believe the defense is aware and the state is aware that the state has the burden to show that the defendant understood his rights. So if anyone wishes to speak to that, you can. I'll hear brief argument.
Sure, Your Honor. So the code says that substantial compliance with the warning is sufficient. And so we believe this, the warning that the defendant was read was either the exact wording required by the code or it was substantially compliant with that. The code also says in the cases that have interpreted the code, say that either that express waiver of the defendant's rights is not required. And that case is, that's Miranda, Joseph v. State, which is 309 Southwest 3rd, 2020. That's a CCA case. And waiver can be clearly inferred from the actions and words of the person interrogated. So Judge, the state's position here is that the defendant was read his rights. The questions that were asked were that he responded to were the officers asking questions for their own safety. Hey, is there I believe the officer asked, are there any booby traps or anything in the house? So when we're searching the house, is anything going to hurt us? And so I think the defendant made this statement, like, hey, there's a gun there, and that might be something dangerous that you might need to know about. I think he made that after being informed of his rights. I think that should be admissible, Judge.
All right. Defense.
Judge, we believe that once the rights were read, clearly he's in custody. Once the rights were read to Mr. Meyer, there was no indication on this exhibit that he understood those rights or that he intentionally, knowingly, and intelligently waived those rights. The officer provided the rights to Mr. Meyer and then immediately began the question. And I think the law is clear that if the questioning is likely to elicit an incriminating response, then it is prohibited in its admission by Miranda and its progeny. We think that's very, very clear. There is no indication here that there was an intelligent, knowing, and voluntary waiver of those rights before Mr. Meyer responded to the interrogation and the question of Officer Salazar. And therefore, we don't think it can be rationally inferred from the exhibit before the court at this time. And we would ask that that statement be suppressed.
All right. Now, the next issue, and I'll make my ruling in just a moment, but the next issue we have is the issue in regards to the search warrant.
Okay.
Right. And defense is asking that the granting of the motion to suppress, which was signed by Judge Jansen, that it be suppressed, correct?
That is correct.
All right. And both parties tendered to the court yesterday the affidavit for the search warrant and also tendered to the court the actual search warrant as well. So the court has reviewed those two items. And also the court has reviewed the case law and the memorandum that was provided by the defense. So with regards to the affidavit for the search warrant and the actual search warrant, does anyone wish to offer that into evidence for purposes of the hearing?
May I approach and do just that, Your Honor?
Yes. Then PT2 and PT3 are admitted into evidence for purposes of this hearing only. And I know that both parties are aware that the parole evidence rule applies. So it's just the four corners of the document. So unless there's witnesses that anyone wish to call, I'll hear argument.
Thank you, Your Honor. Mr. Wilkins informed me, he helped me get this up, and he's willing to help me keep it going now. Thank you, Hank. Your Honor, our suppression argument, of course, is based on the 4th and 14th Amendments to the United States Constitution, Article 1, Section 9 of the Texas Constitution, and Article 38.23 of the Texas Code of Criminal Procedure. As the court noted, this is a four corners argument, and I suggest to the court that I have roped off the meat of this affidavit. That's it. Everything else is just uncorroborated, unsubstantiated, and unpersuasive boilerplate. But this is what it comes down to, Judge. So I'd like to go through this as quickly, and it won't take long, but quickly, but line by line if I can. So it says, affiant received information that narcotics were being used and possibly trafficked from. We submit that nothing in this affidavit would cause a reasonable person to believe that narcotics were being used and possibly trafficked from August 8th, 2022. We go on to suggest to the court and argue to the court that if the court looks, as the case law requires, at the totality of circumstances, does this affidavit give a reasonable, neutral, and detached magistrate a substantial basis for concluding that there's a fair probability that the drugs are in the place they're said to be? And the answer to that, we think, is no, Your Honor. So just on that first sentence, was this information, it says I received information. Was it from a known or an anonymous tipster? That makes a difference to the credibility. But there's no mention at all of whether it's a known tipster or whether it's anonymous. And there's no reference to the tipster after that. And I call the person a tipster. I don't even know if it rises to that level. Was the person providing the information credible and reliable? This, of course, is the two-prong test that was not overruled, by the way, by the Gates decision. In fact, the Gates case said we still regard these two factors as especially important. However, the court went on in the Gates case to say that they're not everything. They're not the be-all, end-all. There can be things that perhaps corroborate the tip beyond credible and reliable, but there is no mention, there is no suggestion. And Your Honor, I say with no hesitation, this is the most insubstantial affidavit I've ever seen. I've never seen in Bexar County at least the boilerplate language not alleged credible and reliable. Had this person, whoever it was, given true and correct information in the past concerning narcotics? So that's the basis of the information test. What was it that caused the person to say that narcotics were being used and possibly trafficked? And I have to say, what a strange way to put that is. Somebody says, I have information that they're being used and possibly trafficked. How reliable is that information just on its face? But had the person ever, no, there's no evidence. There's no reason to believe that the person had ever given true and correct information in the past, whoever this was. That's, again, just boilerplate stuff. Did the person have any known ability to identify narcotics? So that's always said. I rely on a credible and reliable informant who I've used in the past and who's given reliable information and knows how to identify the drug in question. By the way, what type of narcotic is it? That makes a difference.
I have a question for you, counsel.
Yes, ma'am.
And so that, people always say as little as possible, right? When you're a judge. I don't believe in that because I want the communication to be open so that I can let you know what my questions are. So maybe you can address those. So I understand what you're saying about the credible and reliable informant. I do. But it appears from my reading of the affidavit that they're saying, you say it was a tipster. They're saying that somebody informed them that there were drugs at this location. And they're saying that, so what the police did, according to the affidavit, I'm going strictly with the four corners. I'm not going outside the four corners, is that they see someone by the name of Melissa Yanez exit the location, leaves, travels about 100 feet, comes back to the location, and then leaves the house with a black rectangular or dark rectangular bag or box, gets in her vehicle, leaves the location with that box. They perform some sort of a traffic stop, ask her, according to the four corners of the affidavits, to search the vehicle. She says no. They bring K9 out. K9, they say, hits on positive for drugs. And the positive for drugs is from that black box. They open it and they say there are drugs there. So I understand what you're saying about the credible and reliable informant. But my question is, if the police are surveilling a house and it appears they're basing their search warrant from the four corners upon what they saw at the house, do we still need the credible and reliable informant for an officer to sit on a house and watch a house?
Not necessarily, Judge. However, I think it's given what else we have. In other words, many of the cases talk about the credible and or the tipster, informer, whomever and how it is corroborated.
Okay.
And I think we fail in both counts. So I think, and I think Gates says this too. If you're weak on the two-prong test, you can strengthen it and cure it perhaps with adequate surveillance, or vice versa. But here we have neither.
Okay.
I'm happy to go on because I think I'd like to address some of the questions, and I think I do. But if the court has, please interrupt me anytime, Judge.
All right. Thank
I
you.
want to know what the court cares about.
All right. Thank you.
Did the person see? I'm still on the informer, Judge. That it's not an informer; it's a person. That's how that person is identified. Did the person see the narcotics being used in possibly trafficking? So it goes to the basis of their. What were the narcotics? It does make a difference, Judge. Some narcotics are legal and can be prescribed. Morphine, for example, or other narcotics can be prescribed. So just because you saw narcotics, and most search warrants, it may seem like a quibbling thing, but most search warrants will say it's contraband per se. It's methamphetamine or it's cocaine. It's something you don't have a right to have no matter what. Doesn't say here. How much narcotics is hugely important, because if they had said a large quantity, a deliverable quantity, then perhaps someone could infer that it's going to be there for a long time or that it's valuable. We don't know how much it was because the affidavit doesn't say how much this person said was being used and possibly trafficked, using and possibly trafficking the narcotics. Interestingly, this affidavit says that the premises are under the control and charge of Melissa Yanez. And it says, and John Meyer occupied the premises. Now, there's no source for that information, by the way. That is wholly alleged by the affiant without anything like, I checked the property records, I checked the tax rolls. Nobody corroborates that who's in charge of the place and who occupies it. When did this is very important, Your Honor. When did the affiant receive the information? It doesn't say. So did the affiant receive the information 3 days before, 1 day before, 1 year before? I don't mean to get too off the planet, but it ought to be easy enough to say a month, maybe. I mean, give us a month, give us a year, perhaps. It doesn't say month, day, year, or time. How much time passed between the time the affiant received the information and did they set up out there? The reason that matters is because the more time that passes, the less there's going to be of some unknown quantity of an unnamed narcotic. And this is also big, Your Honor, and it's related. When were the narcotics used and possibly trafficked? As the court knows, the language we always see is informant, the credible and reliable informant did see cocaine on the premises being used by a particular person within the last 48 hours. Doesn't give us a time frame at all about that either. So then we get to surveillance, Your Honor. What did they do to corroborate basically what I suggest is nothing? What did they do to corroborate that? We say they did nothing to corroborate that information. So how much time elapsed between August 8th, 2022, the date the warrant was executed, and the date when the narcotics were allegedly used? That's what I just talked about. And it says here, affiant observed Yanez exit the residence and depart in a black Jeep, blah, blah, blah. Affiant, the court saw this. The court already said this, exactly. Entirely innocent behavior, by the way. You leave your residence, you go 100 yards and you come back and you get some item. By the way, what item was it? Dark rectangular bag or box. That's Again, that's not trivial because later on they say that the item found in Giannis's car matched the description, but a bag is different than a box, and a dark rectangular bag is different from a dark rectangular box. So one thing only to bring up there. A probable cause traffic stop was conducted. Sure, that's right. But this is absolutely crucial, Your Honor. When you're talking about the value of surveillance to corroborate an event. How much time passed between Giannis's departure and the traffic stop? Would it have been easy for the officers to say, we saw her leave at a particular time? We don't have that. Doesn't say. We tracked her. We followed her. We didn't lose contact with her. We followed her until the traffic stop. Doesn't say that. It doesn't even say conclusorily that they followed her until the stop. It doesn't give a time. So did Giannis drive around for an hour and a half? Did she stop at 5 different places before she was pulled over for the probable cause traffic stop? We don't know that. And that's important because they're obviously trying to make some link between the drugs found in her car and the drugs that she left with, that they're trying to suggest it came from two. How do we know that? How do we possibly know whether any quantity of drugs was in that bag or box, or what drugs or what quantity? Because we don't have continuous surveillance. We don't even have the allegation of continuous surveillance. We just don't know. Now, was Giannis observed continuously from her departure until the stop? Easy enough to say if it were true, but it doesn't say that here. Did Giannis go? Where did she go before the traffic stop? Again, questions that are unanswered by that affidavit. Then the canine arrived and hit on the vehicle. So this is what I said just a minute ago. The box matched the description. Well, it didn't, Judge. It didn't. Surveillance gave us nothing. So they say they conducted a local criminal history check on Melissa Yanez, not on John Meyer, but a check on Yanez, and found that she has a prior arrest in Bexar County for possession. Didn't say when it was, and we know her date of birth and her SID number. So that adds nothing at all to their case, Your Honor. This is another something. I'm going to go back sort of to the top of the affidavit, though, where I mentioned this a minute ago. It says the premises are under the control and charge of Yanez and occupied by Meyer. But the affiant does not even claim that this conclusion came from information provided by the unknown tipster. We don't know where he got that information. The unknown tipster said narcotics and not methamphetamine. So again, this is an unsourced claim that it is a place where a controlled substance, to wit methamphetamine, is unlawfully possessed. So that's all just uncorroborated, unsourced statement from the affiant that is not supported by whoever his tipster was, who just called it narcotics. That's their affidavit, Your Honor. Given the complete lack of information about the credibility and reliability of the source, about the unknown lapse of time between when she departed and when she was stopped, no reasonable, neutral magistrate could have concluded that the methamphetamine in her vehicle came from, and even if one could make that conclusion, and I suggest one could not, what would give a reasonable, neutral magistrate probable cause to conclude that there was still methamphetamine at the residence at the time the warrant was issued, given that the information was there was an unknown quantity of narcotics being used and possibly trafficked at the location. Just a few of the cases which we've cited in our memo. The core of the Fourth Amendment warrant clause, Your Honor, says that the magistrate may not issue a warrant without first finding probable cause that a particular item will be found in a particular location. We don't have a particular item here, and we don't have a particular location. The test is whether a reasonable reading of the magistrate would lead within the four corners to provide a substantial basis for issuing the warrant. Totality of circumstances, is there a fair probability, not a possibility, Your Honor, is there a fair probability, and is there a substantial basis for that, that evidence of a crime will be found at the specified location? That's Duarte. Schmidt says, the facts submitted to the magistrate must be sufficient to justify the conclusion that the property that is the object of the search is probably on the premises to be searched at the time the warrant issues. Again, given the lapse of time, the scant information provided about quantity and about the substance, how would a magistrate have any basis for concluding that when they went there, when they signed the warrant, when the judge signed the warrant at 4:15, that there would be some illegal narcotics at the location? There's a case called, and the Schmidt case said this: the affidavit in the instant case fails to state when the affiant received the information from Bell. That's exactly our situation here. And if we assume that Bell is the person who informed the officer, or when Bell obtained his information, exactly those three things we are also lacking in ours. There is nothing in the affidavit to demonstrate when the incident it describes took place. This is a Johnson case. The affidavit in the instant case establishes that a specific offense was committed by appellant and that the items sought were evidence that appellant committed the crime. However, the affidavit in Johnson did not give probable cause to believe that the items sought would be located at appellant's apartment. Absent these underlying facts, the judge was unable to make that independent interpretation, and the evidence was ordered suppressed by the Court of Criminal Appeals. Lindley is a case that cites Johnson, and it says probable cause to believe a person has committed a crime does not automatically supply probable cause to search that person's home for evidence. If it did, Your Honor, think about it. I've never seen the police go to somebody's house after an arrest or get a search warrant just because they arrest somebody on the street. There has to be something in addition to just the fact of their arrest. Otherwise, we wouldn't need to distinguish between an arrest warrant and a search warrant. And Casillas, Casillas is a case we gave the court, we cited, where the facts indicate that arising from a reasonably trustworthy source would warrant a person of reasonable caution to believe that evidence may presently be found in a specified place. There is probable cause to issue the warrant. This is premises under control. I talked about that earlier. The Casillas case also says that. In Casillas, the affiant merely asserted that the premises were under possession and control, but that is a purely conclusory statement, the source of which is not given or the reliability vouched for. Same here, Your Honor. That's what we have, Your Honor.
All right. State.
Yes, Your Honor. Can I approach? I have a case. I've provided this to defense. Mr. Over.
Thank you.
So, Judge, since there's a warrant in this case, the burden is on the defense to prove the invalidity of the warrant, and we don't believe they've met that burden in this case. The test is whether a reasonable reading by the magistrate would lead to the conclusion within the four corners of the affidavit provide a substantial basis for issuing the warrant. Probable cause exists when, under the totality of the circumstances, there's a fair probability that contraband or evidence of a crime, will be found at a specified location.
All right, let's do this. If you can start back over.
Yes, ma'am.
With your section that you're reading.
Yes, ma'am. So this is from Duarte, Judge. So the test is whether a reasonable reading by the magistrate would lead to the conclusion that the four corners of the affidavit provide a substantial basis for issuing the warrant. So probable cause exists when, under the totality of the circumstances, there's a fair probability that contraband or evidence of a crime will be found at the specified location. And then this is also from Duarte on the next page at 355. After reviewing the supporting affidavit realistically and with common sense, a reviewing court must uphold the magistrate's decision so long as the magistrate had a substantial basis for concluding that probable cause existed. The focus is not on what other facts could or should have been included in the affidavit. The focus is on the combined logical force facts that are in the affidavit. So the fact that there's some behavior in the affidavit that could have been innocent, that doesn't defeat probable cause, Judge. So the question here is, did the magistrate who issued the search warrant have a substantial basis for concluding that probable cause existed? And we're saying that he did, she did. So the Casillas case that defense just mentioned, the quote from that is, the probable cause to support the issuance of a search warrant exists where the facts submitted to the magistrate are sufficient to justify a conclusion that the object of the search is probably on the premises to be searched at the time the warrant is issued. So, Judge, just from that case I just gave you is Flores v. State. And the reason I gave it to you is that the court goes through, here is what's in the affidavit. So I just like to go through that. I know defense has gone through that, so this is a little bit cumbersome here, but in the affidavit, it states, Brian Wolf has 20 years of experience with BCSO. He has extensive experience with arrests for narcotics violations. He's thoroughly familiar with the information contained in the affidavit. Wolf believes that a place Melissa Yanez has control and charge of and occupied by John Meyer is a place where methamphetamine is possessed. Brian received information that narcotics were being used and possibly trafficked. Within the affidavit, it states that Yanez is stopped for a traffic violation. A canine arrived and conducted a free air sniff and alerted on the vehicle. A black rectangular box was discovered in the vehicle, which contained over 300 grams of meth, packaging, and a digital scale. The substance field tested positive for methamphetamine. The box matched the description of the object that the affiant observed Yanez carrying when she exited 220. Based on the information provided by the affiant and verified through the investigation, coupled with the affiant's training and experience, the affiant has reason to believe and does believe that Melissa Yanez is in unlawful possession of the above described controlled substance to wit methamphetamine. So this Flores case, Judge, so that's just what's in the affidavit. That's just what's within the four corners. This Flores case, Judge, which is a CCA case from 2010, it says that the magistrate could directly find facts from what's in the affidavit. So based on the facts just within the affidavit, the magistrate could directly find that Wolf is a longtime peace officer with extensive training and experience in narcotics investigations. The magistrate could find that Wolf, in the course of his career, has observed methamphetamine use in transactions. The magistrate could find directly from the facts in the affidavit that Wolf conducted an investigation that led him to believe that Melissa Yanez and John Meyer live at 2 before she stopped anywhere else. And the reason I think that's a reasonable thing that the magistrate could have thought is, it's in the affidavit that she leaves, travels 100 feet, and then goes back to the house. It doesn't say, and then she stops somewhere else. That's the only stop that's mentioned in the affidavit, Judge. I think that leads credence to the reason that's a reasonable assumption. Yanez denied permission for the officers to search her vehicle. The canine then came and did a free air sniff and alerted on the vehicle. And then over 300 grams of meth, a scale, and packaging were located in the same black rectangular box that Yanez had left the house with. So our position is the anonymous tip, coupled with an experienced officer's observations during the surveillance, and the traffic stop revealing the drugs in the container that Yanez left the house with, gave the magistrate a substantial basis for concluding that illegal drugs would probably be found in the premises. But this Flores case, Judge, also says that from the facts that we just went through, the magistrate can make reasonable inferences. So the magistrate could have inferred that the information Wolf received was reliable based on Wolf's observations and Yanez being pulled over with 300 grams of meth.
Okay.
Yes, Your Honor.
All right. So with regards to the motion to suppress the search, the court has heard enough information and case law from both parties. But if you all would like to continue with more arguments, of course, I'm willing to hear it. And I know defense is your motion, so you have final argument.
Judge, I always hesitate to talk when the court says it's heard enough. But I do have a response to the Flores case.
All right, you may respond to the
Uh,
Flores case.
Thank you, Judge. It's completely different than our case.
Mhm.
In Flores, there was a tip by someone with some familiarity of the defendant and his affairs. Not here. In Flores, there were several details from the tip that were corroborated later, which the court found significant. Not here. In Flores, totally different than here, the tipster said she had observed cocaine in the home. Again, that's the basis for the information that is totally lacking here. But the crucial facts in Flores are two, I think. One, that in order to corroborate the information, the diligent police officer went on March the 1st and searched the garbage can right in front of the Flores home and found marijuana residue, seeds, and stems. But that wasn't enough. He went back on March the 5th, the day before the warrant was issued, went back again and found more residue, seeds, and stems in Flores's garbage. And the court said, the doctrine of chances. What chances are that if we come to your house with a search warrant looking for marijuana, and based on this information, including the fact that the officer went out not once but twice, what are the chances are that somebody will dump marijuana in your trash can on 2 different days? And the court says, not really. I was surprised, Judge, when Mr. Wilkins said that because somebody surveilling the person at the scene saw her stop within 100 feet, that's good enough to believe she didn't stop at all anywhere else. I don't think so. And finally, I'm really glad he did cite the Duarte case, because that was our case. I have a copy for it, Your Honor.
Oh, sure.
Could I bring the court a copy of Duarte?
I'm aware of the case, but I always love to have copies.
Thank you. The important part about Duarte, of course, is that the Court of Criminal Appeals affirmed the trial court and reversed the Court of Appeals. The trial court granted the motion to suppress. It went up to the Court of Appeals, which reversed, and the Court of Criminal Appeals, not known always as a friendly court to the defense arguments, nonetheless said this affidavit was insubstantial. It contained insufficient particularized cause about the alleged possession. And the language that I think is particularly important from Duarte that mirrors our deficient affidavit is found, Your Honor, on page 359, but it's on page 7 of that Westlaw version. And it says this: the tip was firsthand observation. Okay, that's more than we had here, but it contained no particular level of detail. The tip was, and the court said that he was credible informant, stated he had observed Duarte in possession within the past 24 hours, far more than we have here. But then the court said, the Court of Criminal Appeals said this: that is it. How much cocaine did he possess? A couple of lines worth, laid out at a party and fully consumed? A kilo? Where did Mr. Duarte have the cocaine? In the pocket of his jeans? Hidden in the attic? Was it piled on the kitchen table, being weighed and packaged for sale? This is not a case where there is a tip about methamphetamine lab or marijuana growing operation or crack cocaine dealing. In those cases, the tip supports an inference that the criminal activity is ongoing. Not here, not in Duarte. And that's our argument.
All right, thank you. So what we're going to do is we're going to come back at 1:25 because the court reporter needs a break and everyone needs a lunch break, really. So we'll be back at 1:25. At 1:25, I'll make my decision of course, if it's to deny it, then we'll be done here. I'm sorry, if it's to grant it, we'll be done here. If it's to deny it, we'll continue with our jury trial. You may be seated. All right, I've listened to the argument of both sides with regards to the motion to suppress on the statements and also the motion to suppress the search. And I want to let both parties know I internalized the arguments that was presented to me. And even though I was familiar with the cases that you both presented, I reread everything just to make sure it's as I remembered it. So with regards to the motion to suppress the search, that will be denied. And with regards to the motion to suppress the statement, that will be denied. Are both parties ready to proceed? State,
Ready? Oh, sorry. State's ready, Judge.
defense?
Ready, Your Honor.
Ladies and gentlemen, it's the court's understanding that you've reached a verdict. Is that correct? And is the verdict unanimous?
Yes.
All right, if you'll hand the form to Deputy Laura, please. Thank you. And Mr. Meyer, if you'll please stand. Count one, it states, we, the jury, find the defendant, John Stephen Meyer, guilty of the offense of possession of a controlled substance, namely methamphetamine, which by aggregate weight, including any adulterants or dilutants, was of an amount 4 grams or more, but less than 200 grams as charged in count one of the indictment. Count two, we, the jury, find the defendant, John Stephen Meyer, not guilty of count two. You may be seated. Is there anyone who wishes to have the jury polled? All right, ladies, and is that being polled as to count one only, I'm assuming?
Yes, ma'am.
Ladies and gentlemen, I'm going to ask you whether or not this is your verdict in count one. If it is your verdict, I'll need you to respond yes. And of course, the alternates were not involved in the jury deliberations, so alternates, you will not be responding, of course. And I will start on this end. Is this your verdict?
Yes.
Yes. Yes.
Sure.
Yes. Yes. Yes.
Then on the back row?
Yes.
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 All right, ladies and gentlemen, thank you. All right, ladies and gentlemen, I'm going to have you all step in the back and wait for me there, and I'll come and speak with you. And then if you wish to, the state and the defense will have a chance to speak to you as well. All right, everyone, please rise for the jurors.